Hello, and welcome back to AI Serendipity, where tradition meets innovation and we always ask the hard questions. I'm Santiago Martín Caravaca, an Italian Spanish dual qualified tech and IT lawyer, a technologist by curiosity, and your guide through the twists and turns of the Suno AI case. In this episode, we are unpacking the claims for relief brought by Universal Music, Sony Music, and Warner Music, who are accusing Suno of copyright infringement. These claims don't just aim to stop Suno. They set the stage for the evolving conversation about intellectual property in the age of generative AI. Let's get straight into the details. The first claim centers on post-1972 sound recordings, which are protected under Section 106 of Title 17 of the United States Code. This section grants copyright holders key exclusive rights, including, for instance, the right to reproduce their works, the right to prepare derivative works, such as remixes or adaptations, the right to distribute copies to the public, or the right to perform or display their works publicly. According to the plaintiffs, Suno violated these rights by reproducing sound recordings owned by Universal, Sony, and Warner without authorizations, license, or consent. Specifically, the reproduction right under Section 106, subsection 1, is the cornerstone of this claim. The plaintiffs have presented an illustrative but not exhaustive list of affected works, saying that the impact could extend well beyond the examples cited. The complaint states, upon information and belief, Suno used the reproductions of the Universal works, the Sony works, and the Warner works to train its generative AI model. The plaintiffs argue that these reproductions were to train Suno's generative AI model as it analyzed patterns, melodies, and rhythms from these recordings. Without them, they argue, Suno's AI could not achieve its current level of sophistication. Now, while the complaint places significant emphasis on the reproduction right, it is important to note that the plaintiffs also broadly reference their exclusive rights under Title 17. While these additional rights aren't explicitly detailed in the claims for relief, the plaintiff's language leaves the door open to broader interpretations during litigation. And this strategic ambiguity might allow the plaintiffs to expand their arguments as evidence unfolds during discovery. But the stakes are really high. If the plaintiffs can prove that Suno's actions were willful, that is, deliberate, statutory damages under Section 504, subsection C, could reach up to $150,000 infringed work. Given the alleged scale of the infringement, this could translate into hundreds of millions of dollars in liability. Suno, for its part, counters that any infringement, if proven, was innocent. If the court accepts this defense, statutory damages could be reduced to as little as $200 per work. The distinction between willfulness and innocence will be critical in determining not only the financial consequences, but also the broader interpretation of intent in AI-related copyright cases. The second claim focuses on pre-19 1972 sound recordings, which are governed by a different legal framework. These works, created before February 15, 1972, were historically protected under a patchwork of state laws. This changed with the passage of the Music Modernization Act in 2018. Under the Music Modernization Act, pre-19 recordings now enjoy copyright-like protections. However, the Music Modernization Act introduced an additional procedural requirement. Right holders must register and publicly index these works with the US Copyright Office to qualify for statutory damages and also attorney's fees. The plaintiffs emphasize that they have fulfilled this requirement for all print works cited in the complaint, bolstering their eligibility for financial remedies. Much like the post-1972 claim, the plaintiffs argued that Suno infringed their rights by reproducing these recordings to train its AI model. They allege that this copying constitutes unauthorized reproduction under Section 106 and 1401. This raises a pivotal question. Is training an AI model fundamentally different from traditional reproduction? The plaintiffs assert that even copying for training purposes violates their rights. Suno may counter that their AI output transforms the material into something fundamentally new. This technical distinction between post-1972 protection under Section 106, pre-1972 protection under Section 1401 highlights the evolving complexity of copyright law in the AI age. The plaintiffs' demands in this case go far beyond monetary damages. Their prayer for relief outlines a strategic roadmap for holding Suno accountable, including a declaration of willful infringement. This not only enhances potential damages but strengthens their case for injunctive relief. Injunctive relief to stop Suno from using their works and prevent further harm. This includes barring Suno from facilitating or enabling infringement in any way. Monetary compensation, whether through statutory damages or the recovery of actual damages and Suno's profits. This case is more than just a lawsuit. It is a precedent-setting battle over how copyright law will adapt to the rise of generative AI. If the plaintiffs succeed, it could signal stricter limitations on AI training practices. If Suno prevails, it might pave the way for broader acceptance of AI innovation, even at the potential expense of traditional copyright protections. That's where we'll leave it for today. If this episode sparked your curiosity or left you with questions, don't just listen, subscribe. Join us here at AI Serendipity. In our next episode, we'll dive deep into the plaintiff's prayer for relief and their strategic decision to demand a jury trial, exploring what these legal maneuvers mean for Suno AI, the creative industries, and the future of copyright enforcement in the age of artificial intelligence. Until then, keep questioning, keep asking the hard questions. And remember, innovation is inevitable, but how we embrace it defines who we are. See you next time.